it's a serious threat. I mean, for healthcare entities right now, I'd put it at like an 8 or a 9 for sure right now. Is this a fad that maybe goes away in 6 months and becomes something else? Possibly. But right now, this is a serious threat. For covered entities, for example, under HIPAA, you have, in addition to the lawsuits, you have recent guidance from the HHS Office for Civil Rights that at least creates a question as to whether there's notice requirements by using this pixel technology. So it's significant.
Hi, everybody. My name is Mark Greisiger with Net Diligence. This is a continuation of our cyber risk management blog. We often do these just for industry awareness when we collaborate with our cyber insurance partners. Today, we wanted to talk about a topic that seems to be getting more press and more litigation. It involves metapixel technology and resulting privacy liability issues from that, which is a worry for clients who buy cyber insurance, whether they have insurance or not. It's their worry. It's definitely a worry for our insurance partners who want to make sure clients are aware of this risk and or at least have some kind of risk mitigation practices in place. So I have the great fortune today of talking with an expert in this industry, and it's Alfred Saikali. Al is the chair of privacy and cybersecurity for Shook, Hardy, and Bacon. I've known Al for a few years now. He's been a great speaker at several Net Diligence Cyber Summit events, and I'll be seeing him soon and coming up at the Fort Lauderdale conference, and he'll be talking on this issue. And so this is almost a little bit of a precursor to that. So Al, thank you so much for being here. If you could just give a quick introduction to the audience, and we'll jump right into this.
Thanks, Mark, and appreciate you having me. Just to give you everyone a little bit of background about myself. I chair the privacy and cybersecurity practice here at Shook. I'm in the firm's Miami office. Most of my practice these days focuses on litigation. The firm is currently handling over 250 data privacy and cybersecurity class action lawsuits, so I'm heavily involved in those. We have a separate unit that is dedicated to incident response planning, and general privacy compliance, and we're on a bunch of panels for different cyber insurers as well. So pleasure to be here.
Fantastic. So let's start right off, Al. Like, what the heck is, this metapixel technology that's causing some problems right now? I know it's got privacy liability implications. It's a concern of clients and the cyber underwriters, and is leading to a batch of class action lawsuits. So if you could just start there, that'd be great.
Yeah, absolutely. So there are really 3 kinds of technology that are causing a lot of problems right now for companies that are leading to these lawsuits. One is the use of something called session replay. Session replay is essentially code that is delivered from a website to a browser that then allows the website owner to understand how are individuals interacting with the website. A lot of retailers use this to learn what are people clicking on their site, where are they moving their mouse, how are they doing, so that the retailers can either fix maintenance issues with the sites or otherwise optimize, marketing and make sure that the site is really converting people into purchasing products from the site. The issue with session replay that the plaintiffs are bringing up in these lawsuits is that it requires a third party to essentially receive information about the individual's interaction with the website. And so this is, the plaintiffs allege, a violation of different state wiretap laws and other sort of laws. The second kind of technology that's at issue here is the use of pixels, primarily the metapixels. A pixel is code that is embedded in a website that essentially allows a facilitation of sharing of information about an individual who visits the website. So for example, I'm a Facebook user, right? When I became a Facebook user, something called a C user cookie was downloaded to my browser. And the other thing is that happened when I became a Facebook user is that Facebook disclosed to me the fact that as I travel around the internet, information about my visits to different sites will be shared with Facebook. And so the pixels are a key piece of this, right? Because now as Al travels to site A and site A has a pixel embedded in it, my C user cookie is essentially telling the pixel on that site, you can send information about my visit to Facebook. Why? Because site A is paying Facebook money to make sure that advertisements are shown to Al the next time he goes back to use Facebook. And that those advertisements are shown to people who are like Al, maybe the same geographical area, the same age or gender, whatever it may be. And so the pixels are really just a way to facilitate that. But the key piece here is that I, as a Facebook user, have essentially instructed this site to send that information over to Facebook by visiting the site, having this see user cookie embedded in my browser. So again, though, you see the common theme of a third party receiving information about a visit that I have with a website. The third kind of technology is the use of chatbots. And we've seen these all over the place, right? You can't go to a website these days without something popping up in the corner saying, would you like assistance? Or how can I help you? Do you have any questions?
I mean, beyond, just so you know, beyond annoying.
Right,
Yeah.
exactly, yes. And so the problem is a lot of these chatbots, the services are provided, again, by third parties. So you have this theme, right? This is the thing that connects everything, is there are third parties that are involved in providing the services. And the problem is that there is not a sufficient disclosure by the website that these technologies are in place, right? And so these plaintiffs are alleging, I didn't know that my interaction with the website or my communications with the website was being shared with this third party. And so that's the theme around these different sort of technologies and what's caused the significant uptick in litigation.
That's a good summary. Thanks, Al. Well, let's stay on that. Like, what, I want to know what's kind of causing this wave with these recent large class action lawsuits. Are they leveraging state law, statutory damages? What's enticing these lawyers to get in?
Yeah, so the lawsuits have been around for a while. They've been around for probably several years now. There really weren't as many of these, 5 or 6 years ago. Nothing near what we're seeing now. And then we saw a spike in like late 2020, early 2021. There were about 50 class action lawsuits filed here in Florida that were based on the session replay technology that I mentioned earlier, and essentially all alleging that the use of this technology was a violation of state wiretap law, where there wasn't a disclosure by the website that this technology was in place. Now, those lawsuits pretty much all failed. We at Shook obtained the first federal court dismissals of those lawsuits, and the court there relied on the fact that these people aren't being injured. There's no standing here. This is not what these wiretap laws were created for. And so that dismissal created sort of a snowball that then led to all the rest of them just getting voluntarily dismissed. So we kind of thought it had gone away, but then we saw this new latest wave. And this latest wave is much bigger and is nationwide, and it has really been based on 3 things. Number one was a markup article that was written, I think it was the summer of last year. The article disclosed the use of pixel technology in different healthcare providers' websites and made the argument that this technology is sharing protected health information with third parties, i.e. Facebook, without informing individuals that this is taking place and without having a business associate agreement in place. This, of course, lit the plaintiff's bar up, right? Then you combine that with factor number 2, which were some important decisions that came out from the Ninth Circuit in the assurance case, and then the Third Circuit with the Harriet Gifts case. Both of those allowed these wiretap cases to proceed past motions to dismiss, and essentially said there may be fact issues here, but it did not kick these things out outright, right? And so the plaintiffs bar like, okay, so now I can get these past the motion to dismiss. Seems like there's going to be a significant number of companies that we can sue here. And in the background, they already started taking snapshots of different websites around the country to capture that these websites are using pixel technologies. And then we started to see early decisions on motions to dismiss in pixel cases, and they were not good for defendants. Most of the time, the courts were denying motions to dismiss. That led to then factor number 3, which were some large settlements. The biggest one being, I think it was Mass Brigham, that had like an $18 million settlement. So you want to put blood in the water.
Oh my gosh. I mean,
throw them an 8-figure number out there as a settlement. So we've seen, I mean, anywhere from 5 to 10 of these lawsuits were getting filed per week for a period of time. And we're still seeing a bunch of them getting filed. In California, the litigation is like off the charts crazy in terms of the number of these lawsuits that we're seeing. So that's how these things progressed and came to the point where we are today.
If you had to rank this, let's just say if you're a risk manager, you're in a company, you're trying to gauge, you're hearing about this for the first time, how serious of a threat this is for most companies on a scale of 1 to 10, and where would you put that? And is there certain companies in certain sectors maybe more susceptible?
Yeah, it's a serious threat. I mean, for healthcare entities right now, I'd put it at like an 8 or a 9 for sure right now. Is this a fad that maybe goes away in 6 months and becomes something else? Possibly. But right now, this is a serious threat. For covered entities, for example, under HIPAA, you have, in addition to the lawsuits, you have recent guidance from the HHS Office for Civil Rights that at least creates a question as to whether there's notice requirements by using this pixel technology. So it's significant. For retailers, the use of session replay is becoming the basis for these lawsuits in California. On almost a daily basis, we're seeing new ones getting filed. So, that's for sure a big problem. And then companies that embed pixels in videos as well. You have these statutory claims, like in addition to the state wiretap law, you have the Video Privacy Protection Act, and those lawsuits continue to proceed. So I think for all of those, it is definitely a concern. But I think here's the thing, Mark, like now today we're talking about, we're talking about pixels, we're talking about session replay, we're talking about chatbots. But 6 months, a year or two from now, we'll just be talking about a different kind of ad tech that's out there, right? It's the common theme that our clients and insurance companies need to be thinking about, which is there some sort of communication that's taking place between the visitor to the website and the website itself that's being shared with a third party, whatever the form of that may be, and are we providing sufficient disclosure for it? And there are some ways certainly to mitigate some of the risks, but the for now, I think it is a real threat given the number of lawsuits that we're seeing, and the lack of any real defense friendly decisions that we can all cite to and say, look, here's some really well-reasoned precedent that's out there, and we're seeing a tide turning. We're not seeing that yet. So it's a concern.
Yeah, I mean, I would say, this is definitely starting to catch the attention of the lead cyber underwriters out there when you get those kind of large settlement figures that you mentioned. We speak to clients every day, insurance partners, we have our conferences, attended by thousands. And we're always talking about cyber risk. I put air quotes around that because most of those discussions around cybersecurity risk, ransomware, whatnot. But in many ways, this is even more threatening to the balance sheets of a lot of companies. And it's really under, I guess, the umbrella term of privacy, wrongful collection, wrongful sharing via pixel technology. And it continues to morph.
And to your point, it's kind of like, we've all been worried about what's happening with BIPA, for example, and the hundreds or thousands of lawsuits getting filed there because of statutory damages. Well, this could be like BIPA on steroids, because you've got, now it's nationwide and it's based on statutory claims that create significant damages. And how do you even measure the number of people that visited a website, right?
Yeah.
How do you put that or measure that exposure?
Oh my gosh.
Yeah.
It's kind of mind boggling. Well, let's talk about solutions. I guess we'll end there on the solution side. Let's talk about, from the vantage point of a cyber underwriter, what can they do if they're looking at a client they want to insure for, again, cyber risk? How can they evaluate this kind of exposure? And then also touch, Al, if you can, on what can the actual cyber policyholder, the company, do to mitigate this exposure?
Yeah, so I think there's a lot of overlap there. So if I were in the shoes of an underwriter right now and I needed to assess this risk in an applicant, I would first ask the applicant, do you use any of this kind of technology? Whether it's pixels or session replay or chatbots, and maybe ask the broader question, or any other technology that may share information about website visitors with third parties. There are also some tools that insurance companies can use to independently verify by scanning the website whether these tools are being used or not. But I think asking that question for sure. And then I think, okay, if the answer is yes, we do use it, then asking how has the technology been configured? Because you can configure some of these technologies in a more privacy friendly way that minimizes the amount of any identifiable information that may be shared between the visitor and the website or the third party. So the configuration is the second thing I'd be asking about. I think asking then about any agreement that may be in place between the vendor of those tools and the applicant to find out, are there indemnification rights there, such that if you are sued as the website owner, you have some potential ability to seek indemnification from the vendor for that lawsuit. I think also asking about whether there are disclosures in place, right? So if the answer is yes, we use it. Okay, well, what do you tell people about it? What does your privacy notice say about it? And here's an important, like a pro tip, Mark, is you can't just have this in the privacy notice that's buried at the bottom of the site, because the plaintiff's lawyers are pleading their way around it, saying, look, this recording with session replay or the pixels started the moment I hit the site, right? And if you wait until you get all the way to the bottom to look at the privacy notice, it's too late. So how do you mitigate that? You got to have a pop-up that comes up right away, right? That maybe contains a link to the full privacy notice if you want. But that's the best way to mitigate that risk for sure. And then I think also just, for more proactively, if I were to like head of underwriting at a carrier, I'd say, okay, what are we doing to educate our existing insureds or clients about these risks? Let's send them pointers. Let's send them an alert that says, here are these kinds of risks, and here are some tips on how to mitigate them. Because if you can mitigate these, imagine, the potential millions of dollars that you've saved in litigation as a result of doing that kind of thing. And you don't have to be perfect in what you do. You just have to be sort of like the least slowest, not like gazelle kind of thing, a little bit faster than everybody else. You have to have some sort of disclosure out there. You have to do something with some of this, So that's what I would do if I were in that position.
So if you're a risk manager who buys the insurance policy, I mean, ultimately you need to discuss internally this with, I guess, your marketing persons and possibly IT people who know about their connection to Google, to Facebook, I guess, right? I mean, and can you decouple from Facebook, I guess?
Right. It's so true. Like one of the things you hit on there is this disconnect between marketing departments and legal departments, right? Imagine if legal departments have been talking to marketing, say, wait, marketing, you guys are using what on the website that's tracking visitors, and who is this sharing it with? And you don't say anything about it, right? Like if you like that disconnect is what is part of the problem here. And hopefully risk managers are identifying that to say, okay, that's a bridge that we need to create at the organization.
Well, Al, this was fantastic. Thanks for summarizing this whole conversation. I really look forward to seeing you in person then in sunny Fort Lauderdale in a few weeks and really diving into this session. So with that, I want to thank you, and we'll talk soon.
Sounds good. Thank you so much, Mark. And I promise for everybody who attends the session, I will try to bring as best hometown weather as we can here in Fort Lauderdale. So come on down from the Northeast and from the cold, Northwest and visit us. And I promise this will be an entertaining session.